Many Democrats have been making explicitly clear that they believe the number one political issue that will help them win the 2024 election are not things like inflation or job security or the border or the war in Ukraine or the war in Gaza or anything else like that. They believe it is that people will turn to the Democratic Party because the Democratic Party is the only bulwark, the only safeguard, the only guardian to protect American democracy from assault. And among the many problems with this hypothesis, including the fact that of all the things Americans worry about most, they're going to go to the polls and yet again vote based on what happened 4 years earlier on January 6th, which is what one leading Democrat insisted would happen today. It is very difficult for a party such as the Democratic Party to insist that they are the safeguards, the guarantors of democratic values, when they are simultaneously the party that is having their political opponents routinely censored from the internet, including having Donald Trump censored from the internet, having negative reporting about Joe Biden censored before the 2020 election based on a CIA lie that it was Russian disinformation. Censorship doesn't seem to be a value typically associated by Americans with preserving democracy, nor does trying to have your primary political opponent, who all polls show is leading in the presidential race, having him put in prison and desperately trying to accomplish that before the election. And what particularly does not seem compatible with the attempt to proclaim the Democratic Party the saviors of American democracy is this ongoing attempt over many months to try and ban Donald Trump from the ballot, to prevent Americans from voting for him if they wish to, based on the theory that he was guilty of a crime with which he has never actually been charged, let alone convicted, which is the crime of insurrection. This theory began in sort of the most extremist liberal resistance precincts, people like Harvard Law professor Lawrence Tribe bringing it to MSNBC and then writing articles about it in The Atlantic. And yet, like so much these days, it's spread throughout all of liberal media, even though it was long considered a preposterous and a fringe idea, the idea that you could ban Trump from the ballot, even though he's not been convicted of or even charged with a crime. It's so intuitively repellent to anybody who believes in basic democratic values, and yet they were able to not only bring lawsuits around the country alleging this theory, but they got the Colorado Supreme Court, a court full of Democratic Party appointed judges, all 7 of them are Democratic appointed judges, and by a 4-3 ruling, which means the ruling was a step too far, even for 3 Democratic judges, they ruled that Trump could actually be banned from the ballot, must be banned from the ballot on the grounds that he was an insurrectionist. And after that, multiple Democratic Party officials in other states looking to make a name for themselves, liberal judges in other states followed suit and also banned Trump from the ballot. And it was clear that this was going to go to the Supreme Court. An oral argument was held about a month ago, and we covered it at the time. And it was clear then that the judges, almost all of them, were hostile to the argument that Trump could be banned by Colorado. And we said at the time we thought it was going to be a unanimous ruling against him. If anything, maybe that the state of Colorado would get one judge who I thought could be Ketanji Jackson Brown, but I didn't even think they would get her, and it turns out they didn't. Today, the Supreme Court issued a 9-0 ruling rejecting pretty aggressively the ruling by the Colorado Supreme Court, and ruling that states have no ability, no power to ban federal candidates for federal office from appearing on the ballot on the grounds of the 14th Amendment. Here's the New York Times headline: Supreme Court rules Trump will stay on the Colorado ballot. The justice ruled that the 14th Amendment did not allow states to bar the former president from the ballot. The justices gave different reasons, but the decision was unanimous. And that is not quite true, that the justices gave different reasons. They actually all agreed on not only the fact that states have no power to ban presidential candidates individually one by one from their ballots, they also agreed on the rationale for it. The only thing they disagreed on was what Amy Coney Barrett, in that quote we read to you, described as a very kind of trivial and ancillary issue in the scheme of things, namely whether or not, once the court decided unanimously that states have no power to ban a presidential candidate like Donald Trump, 5 of the justices on the court, the conservative justices except Amy Coney Barrett, went on beyond that ruling to say only Congress has the power to execute the 14th Amendment, and the liberal justices wanting to preserve the ability, perhaps of the executive branch, of the Justice Department, of other agencies under the control of the president to also implement the 14th Amendment, objected to the fact that the court did not need to just go beyond the ruling on which they all agreed that states had no power. And those 5 justices went on to say only Congress does. And the liberal justices with Amy Coney Barrett objected and said, this ruling is unnecessary. It shouldn't be part of the ruling. We should just all agree that Colorado got this wrong, that states cannot ban a president. But on the core, a presidential candidate, but on the core issue, the issue that was the one that mattered, the issue that liberal pundits and lawyers and legal experts spent the last several months trying to convince people was a viable, valid argument. In fact, the stronger one, the court united with, I would say, a pretty strong contempt for the argument. It appeared at oral argument as we reported at the time. We took you through some of the exchanges with the judges. I said at the time I had rarely seen so much hostility, open hostility, on the part of Supreme Court justices to the lawyer representing Colorado when advancing that position. It turned out that's how this ruling was formed. Now, it's not a long ruling, and we're going to just show you the key highlights because we think it's important to understand the substance of a ruling, not just the outcome. So here from the Supreme Court ruling today, March 4th, there you see the title of the ruling. It's Trump versus Anderson. Norma Anderson is one of the plaintiffs that they recruited in Colorado. The lawsuit was organized by a liberal advocacy group called CREW. But because they needed independent and Republican voters, since they're the only ones with standing to sue, they got, never Trump types who were willing to be used that way. But it was really a liberal lawsuit, a Democratic Party liberal lawsuit. And here's what the majority in the Supreme Court said. In fact, this is the full court speaking. Quote, "This case raises the question whether the state, in addition to Congress, may also enforce Section 3 of the 14th Amendment. We conclude that, quote, states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. The respondents, meaning the state of Colorado, nonetheless maintain that states may enforce Section 3 against candidates for federal office, but the text of the 14th Amendment on its face does not affirmatively delegate such a power to the states. The terms of the amendment speak only to enforcement by Congress, which enjoys power to enforce the amendment through legislation pursuant to Section 5. In other words, when the 14th Amendment was enacted, it provided an enforcement mechanism. Section 5 says that Congress shall enforce the provisions of Article 14, not that the state shall. In other words, you need Congress to say that the president committed insurrection and therefore should be banned from the ballot. The court went on, quote, "Nor have the respondents identified any tradition of state enforcement of Section 3 against federal office holders or candidates in the years following ratification of the 14th Amendment. Such a lack of historical precedent is generally, quote, a telling indication of a, quote, severe constitutional problem with the asserted power." They went on, quote, "But the notion that the Constitution grants the states freer rein than Congress to decide how Section 3 should be enforced with respect to federal offices is simply implausible. State enforcement of Section 3 with respect to the presidency would raise heightened concerns. Conflicting state outcomes concerning the same candidate could result not just from differing views on the merits, but from variations in a state law governing the proceedings that are necessary to make Section 3 disqualification determinations. Some states might allow a Section 3 challenge to succeed based on a preponderance of evidence, while others might require a heightened showing." Meaning, if you allow states to do this, you're just going to get a huge hodgepodge of decisions, different conflicting decisions from states, not just because they might see it differently, but because they all have different rules for how to make these determinations. And there's no way to have a federal election with certain states ruling that a candidate can't appear, other states ruling that it's fine. This is reserved solely for the federal level because it's a federal election, said the court. Quote, "Certain evidence, like the congressional report on which the lower courts relied here, might be admissible in some states, but inadmissible hearsay in others. The result could well be that a single candidate would be declared ineligible in some states but not others, based on the same conduct, perhaps even the same factual record. So essentially the majority said that the text of the Constitution, the way it's structured, leave no doubt that states are unauthorized to ban candidates for federal office, certainly including the presidency. And that as a practical matter, it's absurd to think that it could work that way, because you would get this mismatch, this hodgepodge of all these different rulings, and it violates principles of federalism, the idea that we have a state system and a federal system, so state courts can rule that certain candidates can't appear on ballots because they violate the state constitution if they're running for state office, but that is not within the power of the states under the Constitution to do, but only the federal government. They all agreed on that proposition, all 9 of the judges, including Kagan, Sotomayor, and Brown Jackson. Thanks for watching this clip from System Update, our live show that airs every Monday through Friday at 7 p.m. Eastern, exclusively on Rumble. You can catch the full nightly shows live or view the backlog of episodes for free on our Rumble page. You can also find full episodes the morning after they air across all major podcasting platforms, including Spotify and Apple. All the information you need is linked below. We hope to see you there.